Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
And again, to emphasize, this was the government's proposed solution to Judge Murphy.
Yeah, and yet the government actually raced to the Supreme Court, skipping the First Circuit entirely, to whine to the justices that Judge Murphy is, quote, usurping the executive's authority over immigration policy and disrupting sensitive diplomatic foreign policy and national security efforts by not letting them deport immigrants to war-torn hellholes without due process. Welcome to Law and Chaos. Today on the show, it's Trump versus Harvard, and Trump loses. It's Trump versus law firms, and Trump loses. It's Trump versus tariffs, and Trump loses, although the game is going into extra innings. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Ty, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I'm good.
I'm glad to
looking
hear
forward to the weekend. How about you?
I'm much the same. It's supposed to be a little nicer. It's been cold and rainy here, and that's gross, and no one needs that.
I had to turn the heat on this morning. I was so pissed. Then I had to turn the heat off. So, can't win. Okay, we have so much to talk about. We have, for Docket Alerts, we have 3 items, 3 of them infuriating, 1 of them positive. So let's start with a little infuriation. That would be Emile Beauvais, Donald Trump's personal criminal lawyer, whom he actually went through with it and nominated to the Third Circuit.
I didn't think that was going to happen. I thought that was a troll all the way around, right? Like, Beauvais is not going to be well received by the other judges on the Third Circuit. I don't think it's going to take him out of Trump's immediate grifting orbit. Like, I don't understand. This seems like an awful lot to troll the libs, and they got a lot going. So.
Yeah. Look, first of all, this is that seat that was left open because Democrats refused to confirm Adil Mangi, the Muslim nominee whom Joe Biden nominated. So that's on us. Second of all, Beauvais has disqualified himself in such spectacular fashion. He's the one who engineered that nonsense around dismissing the case against Eric Adams. Mm-hmm. He's gone after January 6 prosecutors. He's leaned on people to prosecute Democrats for fake crimes. He's so spectacularly disqualified. And I thought he wouldn't be nominated because I think it will be so unpleasant for him to have to go through the confirmation process in front of the Senate, where Democrats are going to ask him a lot of questions he does not wish to answer. But what he will be spared is having to answer questions from the American Bar Association. Let me read you a little bit of this letter from Pam Bondi, which was published earlier today. It said, unfortunately, the ABA no longer functions as a fair arbiter of nominees' qualifications, and its ratings invariably and demonstrably favor nominees put forth by Democratic administrations. The ABA's steadfast refusal to fix the bias in its ratings process, despite criticism from Congress, the administration, and the Academy, is disquieting. Accordingly, while the ABA is free to comment on judicial nominations along with other activist organizations, there is no justification for treating the ABA differently from such other activist organizations, and the Department of Justice will not do so. Specifically, the Office of Legal Policy will no longer direct nominees to provide waivers allowing the ABA access to non-public information, including bar records. Nominees will also not respond to questionnaires prepared by the ABA and will not sit for interviews with the ABA.
Yeah. Isn't it possible that the reason why the ABA ranks Democratic nominees more qualified than Trump's nominees is because Democratic nominees are more qualified than Trump's nominees? I mean, their criteria are transparent, right? It is 12 years of practice in the law, right? It is relevant experience before you assume a seat on the federal circuit. And, Trump would like to nominate 9-year-olds incubated at the Federalist Society to lifetime appointments. So, not surprising. I should add that HuffPost legal reporter and friend of the show, Brandy Buckman, says that the ABA president, Bill Bay, told the Conference on Professional Responsibility this week that it is not just judges who are under threat, thanks to, Bondi's rhetoric and this kind of rhetoric. Bay says that the police come by his house twice a week due to threats that he receives.
Yeah, and just to backtrack, right, the juxtaposition of Bondi saying, well, ABA is mean to Republican nominees, and Trump nominating his wildly unqualified lawyer, not just because he's ethically compromised, but because he's never been a judge, right? Nominating somebody for the federal circuit who hasn't been a prominent practitioner, right, it's such a tell that these nominees are getting, rated as unqualified because they are unqualified.
Right.
Okay, you know what? Let's get our gross news out of the way. I'm going to read you this excerpt, Andrew, from the Wall Street Journal. It says, Harmeet Dillon, head of the Civil Rights Division at the Justice Department, wakes up around 6 a.m. and begins her workday scrolling through X, that is Twitter, searching for claims of discrimination. A lot of them, Dillon said, regard universities. After spotting a list of new horrors, she said, I text my deputies and we assign cases and we get cranking.
Sure. I mean, the fact that the Civil Rights Division at the Department of Justice is being run by somebody who wakes up every morning scrolling the Nazi bar, like that's the least surprising bit of news we've ever broken on this show.
Yeah, that reminds me so much of during the first Trump administration, where I used to write for the website Wonket. And my boss used to say, Twitter is not your assignment editor, right? The fact that it's trending doesn't mean that it's news. And for God's sake, this woman actually thinks that Twitter is her assignment editor and she's running the Civil Rights Division at Main Justice.
Yep.
Okay, well, one of the good side effects, I guess, from having incompetent nitwits running the Justice Department is that they screw up all the time in court. And case in point, the congestion pricing case before Judge Louis Lyman in the Southern District of New York. Louis Lyman, he appears a lot on this show. He had the Rudy Giuliani case with the 2 poll workers, and he has the Justin Baldoni Blake Lively case, God help him. And he's also got this case where the Secretary of Transportation, Sean Duffy, a former The Real World star, is he as soon as he got into office, he tried to cancel congestion pricing in Manhattan, which was approved under this pilot program in the Biden administration. And Duffy basically just did it. He didn't really cite anything other than I'm canceling this because I can, and I'm going to threaten you a whole lot with losing all of your federal highway funds if you don't do what I want.
Yeah, and correct me if I'm wrong, but isn't congestion pricing wildly popular in New York? It has achieved its objectives. It has reduced
Correct.
Traffic. Yeah, okay. Just making sure. I don't know New York that well.
So, so Judge Lyman says there is no termination clause in this grant, and it would be, quote, nonsensical for the court to read one in at the government's behest based on some theory that capping the number of grants implies that each new president gets to reallocate them. True story. They really did argue that. They also argued a bunch of crazy other shit.
Yeah, it's hard for me to keep track. Because remember, this is the case where the DOJ lawyers inadvertently filed an internal memo to the aforementioned Transportation Secretary Sean Duffy on the public docket. In that memo, they waived attorney work product privilege. It contained, significant amounts of legal advice in which his lawyers said your legal position was garbage, that you were going to lose, and that you were likely to wind up Mr. Duffy being deposed along the way based on your statements. So, great lawyering all the way around.
Yeah, these guys are just so captured by Fox News that they no longer see real life. Duffy thinks that his job is going on the morning shows and saying how gross and dirty this subway is, and that's actually a legal argument, which which it is not. So Judge Lyman enjoined enforcement of this order. He said that congestion pricing will have to stay in force through the trial. This is a preliminary injunction. And he added this sort of interesting clause at the end. He said, for the avoidance of doubt, defendants are enjoined from taking any of the compliance measures set forth in the April 21, 2025 letter, including withholding federal funds, approvals, or authorizations from New York State or local agencies to enforce compliance with or implement this order to end congestion pricing. So basically what he said here was, you have been trying to put the screws to these people to get them to do what you could not legally do by terminating this agreement. And you better not do any of that because I got my eye on you, which is a pretty strong indication that they've behaved in a totally squirrely manner here.
Yeah.
So what do you think here? I mean, about the likelihood. Obviously, this is going to get appealed. They'll appeal to the Second Circuit. I think that the Second Circuit's going to give them the back of the hand. But do you have further thoughts on that one?
I mean, I guess my thoughts are it depends on, we have not yet seen how the Supreme Court has taken a position on the administration's expansive view of the carrot and stick power, right? Like you would expect a conservative court to say, we are going to narrowly construe the power of the executive to condition funds on doing unrelated stuff, right? Like that's what the Rehnquist court did for forever. It said, we're not going to let you, withhold highway funds if, you do unrelated issue, right? Like that's how that body of case law developed. The Supreme Court has not always been consistent and has been awfully deferential to Trump. Yeah, right. So, we're going to, my point is that for the Roberts court, this is going to be, an issue of first impression. I know where the law is, but can't say I know where the Supreme Court is going to be.
Yeah, I agree. I think this is one of those where the Supreme Court could kind of root around and fashion some sort of quasi statutory interpretation. They could say like, well, we've, found this little subclause and the way we read it, will allow the president to have maximal power. I mean, that wouldn't make any sense, but we're talking about a court that just said basically Trump can fire everyone but Jerome Powell. So clearly they're not, it's all Calvin Ball.
Well, and yeah, right. And speaking of trying to navigate the Supreme Court.
Yeah. On Tuesday, yet another trial judge struck down one of Trump's deranged executive orders targeting big law firms. This time it was senior judge John Bates. He's a 78-year-old George W. Bush appointee on the U.S. District Court for D.C., and he entered summary judgment in favor of Jenner and Block on virtually every count, issuing a permanent injunction blocking Trump's retaliatory executive order that purported to rescind Jenner's security clearances, bar it from government contracts and government buildings, and prevent any government agency from hiring any Jenner employee or doing any business with any of Jenner's clients.
Right.
This is the same conclusion that every other court to reach the question has held. Trump has gone after Perkins Coie and Sussman Godfrey and WilmerHale and Jenner. And in the case of Jenner, it's because his former nemesis, who worked on the Mueller report, Andrew Weissman, used to work at Jenner. And so Trump hates Weissman, and so Jenner is bad. This opinion comes from yet another old bull. We've had this discussion about how all of these old judges who are like Reagan appointees and George W. Bush appointees, who are conservatives, have just like had it with Trump. They kind of remind me of this character from King of the Hill, Cotton, like Hank Hill's dad, Cotton Hill. And he's like, he's like a terrible old guy, but he's like, I hate Nazis, every time he like sees somebody. Like that kind of reminds me, like I read these opinions and I think, wow, I don't agree with you on any other thing, but you certainly like are holding the line, sir. And so Judge Bates handed down this really thorough, methodical roadmap as to why the administration can't target law firms it doesn't like.
Yeah. I like that you've seen like 7 TV shows and one of them is King of the Hill. Anyway, I think the best way to understand Judge Bates's order here is by contrast to another permanent injunction that was issued the same day in the same court by another conservative George W. Bush appointee, also in his 70s, against a virtually identical executive order. That's the one targeting the firm WilmerHale. talked about. And in that case, it was Judge Richard Leon, and rather than measured and methodical, he let loose with both barrels. I control.
That was Cotton Hill.
It was great. I control F'd that opinion. There are 27 exclamation points in it, and look, like from a lawyer's perspective, like one is a lot from a federal district court judge, right? 27 is absolutely, I feel confident saying that is going in the Guinness Book of World Records. So, right, like, and it's not just kind of random, like what Judge Leon did was he would frequently like summarize a Trump administration argument and then reply with things like, so these are some actual quotes, please, or please, that dog won't hunt, or it is certainly not clear to this court. All of these followed by exclamation points. Or my personal favorite, this order shouts through a bullhorn, if you take on causes disfavored by President Trump, you will be punished. And
please.
True. Like, and look, from a strategic perspective, it is certainly emotionally satisfying to read someone as angry at this stuff as you and I are, right? But I am not sure that that's the best recipe to get through, the DC Circuit and then the Supreme Court.
Yeah, it's interesting. We're still waiting on the one order for the Sussman Godfrey, which is Judge Lauren Ali Khan, and she's fairly young. I believe she's a Biden appointee. Yes. But so far, we've had these three opinions from what we would term as old bulls, and I say, I include Judge Beryl Howell in that, with absolute love and respect. I think she's an absolute hero. But she wrote this 120-page order where she basically called out the VC law firms. Yeah. And as you said, we're gonna talk in the subscriber bonus about Judge Leon's order. But Judge Bates's order is very, very measured, and it's deferential to the administration, but it also doesn't pull any punches. And the end result is almost entirely the same as where Judge Howell got to in the Perkins-Coie order and where Judge Leon got to in the WilmerHale order. But I suspect you're right that Justice Barrett will be less offended by this one. Yeah. For example, Judge Leon's order enjoins the entire executive order against WilmerHale, lock, stock, and barrel. Judge Bates does not enjoin the first section, which is, I think we called it the "you suck" section, where Trump kind of vents his spleen and says that Jenner and Block sucks because Andrew Weissman sucks and they sue the government and they're bad. Judge Bates says Section 1 does not direct any action. It represents instead something of a screed airing the president's grievances with Jenner. In the executive order as issued, the screed played an essential role. It both supplied a rationale for sections 2 through 5. That's the sections where it said, discriminate against Jenner employees. Right. And answered any questions those operative sections purported to leave open, like whether engaging with Jenner is in the national interest.
Right. Answered them with no. Yeah.
Right. So it said the court is very sympathetic to Jenner's request. The president has displayed a great deal of animosity towards Jenner. Further adverse actions would not be shocking and could very well offend the Constitution as plainly as this executive order does. But he said, I can't restrain the government from saying mean words about you. I can't restrain the president from being a dick.
Right.
I can restrain him from acting on his dickish thoughts, but I can't restrain him from saying them.
Yeah, that's right. And there is even a citation to that Pam Bondi Russ Vogt memo that you read on the show, right? That basically says we might pull back, but we're going to reserve the right to go after any law firm at any time that's not acting in the national interest, right? Like I think that read is correct. And ultimately, Judge Bates said, look, this relief is just too abstract, too speculative for me to enjoin. And there is so much more that you and I want to talk about here, including how Judge Bates dealt with the administration's arguments that, you think are likely to have a more receptive ear with the conservative judiciary, especially the Supreme Court, particularly the argument about revoking security clearances. And I really want to talk about how the National Rifle Association trying to secretly negotiate an illegal insurance arrangement might have given all of us a leg up in protecting law firms from being bludgeoned about the head by Donald Trump. So if you want to hear that, you know what to do. Head on over patreon.com/lawandchaospod or lawandchaospod.com and sign up on Substack. And you'll get the extended part of the episode. You'll get ad-free episodes. You'll get all our bonus stuff. For everybody else, we'll see you on the other end of this brief ad break.
I earned my degree online at Arizona State University. I chose to get my degree at ASU because I knew that I'd get a quality education, they were recognized for excellence, and that I would be prepared for the workforce upon graduating. To be associated with ASU, both as a student and alum, it makes me extremely proud, and having experienced the program, I know now that I'm set up for success. Learn more at asuonline.asu.edu.
And we are back. Okay, we talked last week about the government's ongoing attacks on Harvard University. The Trump administration has already tried to take all government funding away from the university. That's mostly science funding. It's really going to be an absolute bloody disaster.
Yeah.
But DHS Secretary Kristi Noem decided she wasn't going to be shown up by Linda McMahon and that lunatic Kennedy. So she decided she would kneecap Harvard by taking away its ability to enroll foreign students and instructors.
Yeah, we talked about this at length on Tuesday's show, and we said that Judge Allison Burroughs had issued a temporary restraining order barring the Department of Homeland Security from locking the school out of the Student and Exchange Visitor Program, SEVP. Thursday morning, Judge Burroughs held a hearing in her courtroom in Boston, and she said she's going to turn this into a preliminary injunction and that the parties need to submit draft language. That is not at all surprising to us, Liz, since, there's a process to kick a school out of SEVP, and it is not sending a series of nasty letters demanding loads of information you're not entitled to by law, and then arbitrarily terminating their access from one day to the next. And so now we're seeing the administration belatedly try and back formulate some kinds of pretextual justifications for, claiming that they actually did comply with the statute.
Yeah, so a lot of the media is referring to this as like backpedaling or softening their stance or whatever. And I just think that misses the mark, right? This is more like going through the steps after the fact to manufacture an excuse for the government's illegal conduct. Because what they've done is send something that looks sort of like a notice of intent to withdraw the school's SEVP certification that accords with the federal regulations. So they say the compliance issues, each sufficient by itself to warrant the withdrawal of certification, identified in this case include 1, failure to comply with reporting requirements, 2, failure to maintain a campus environment free from violence and anti-Semitism, and 3, practices with foreign entities raising national security concerns.
Yeah, this is more of a notice of intent-shaped object, really. It says that the school's responses to DHS's queries were insufficient, but it doesn't say how. It just points in a direction of a May 7th letter.
Well, luckily for us, Harvard docketed that May 7th letter and the responses as part of its complaint. So we know exactly what happened here. And it is that Department of Homeland Security's General Counsel, Joe Mazzara, he appears in all these cases. He demanded information on any student visa holder who engaged in 1, illegal activity and whether the activity occurred on campus. 2, dangerous or violent activity and whether the activity occurred on campus. 3, threats to other students or university personnel and whether the activity occurred on campus. And 4, deprivation of rights of other classmates or university personnel and whether that activity occurred on campus. So after that, there was a back and forth about what statute or regulation DHS was basing this demand on. And here's Harvard's response. They said there were no criminal convictions for any visa-holding student. No foreign student had been disciplined for violent conduct, except for one student who withdrew in September of 2024 for, quote, inappropriate social behavior involving physical violence, a dangerous weapon, parentheses, portable speaker, so I don't know what he did with the speaker, and drugs and alcohol.
Well, now I have some ideas.
Yeah. And they said there were a couple of student athletes who were placed on probation for, quote, inappropriate social behavior involving alcohol. So that's it, right? And they said, basically, we don't know what the hell you mean by deprivation of rights, since that appears nowhere in the SEVP regs, but, quote, federal statutes that use similar formulations refer to rights secured by the Constitution or statute. Harvard's canvass of its schools did not reveal any F1 student found in the disciplinary context described above to have deprived a classmate or university personnel of such rights. If you intend something else, please let us know, and upon receipt of clarification, we will promptly reply in accordance with applicable law.
Yeah. From a practitioner perspective, right? This is the school very clearly trying to comply in utmost good faith, right? To go above and beyond what they know is required so that when they march into court, they can say, we did everything that was required of us and then some, which is why the government's, notice of intent shaped object just says they were non-responsive, and it doesn't say how they were non-responsive or, and again, this is really, really important from a legal perspective, what Harvard could have done to cure the deficiency. And then I got to tell you, the rest of this document is just gobbledygook, right? Like it accuses Harvard of fostering anti-Semitism and failing to protect Jewish students. And look, like I am not trying to say, particularly right now, that there's not a problem of anti-Semitism on college campuses, but like that is not a basis for withdrawing a school certification under SEVP.
Nor is it anything like the problem that they're pretending it is. I mean, they've made it sound as if Harvard students are manifestly physically unsafe at all times. And that's just wrong. I mean, I am a parent of Jewish college students. I do have some feelings and insight about this matter. And I really don't appreciate being co-opted as an excuse to suppress free speech and attack higher education writ large. Like, leave us out of your shit, Christy.
Right. Here. So the letter also says that this supposed failure by Harvard to protect Jewish students merits removal from the SEV program under Title VIII, Section 214.4, Sub A, Sub 2, which, like, if you're not a lawyer, that sounds really, really specific, except that 214.4A2 has 19 different subsections that are potential reasons for decertification. They are numbered 1 through 19, and those are little Roman numerals, so it's XIX. And like, the administration doesn't say which one of those 19 that they mean, so how is Harvard supposed to fix it? Spoiler alert, they're not. But wait, there's more. The letter also says, evidence obtained by DHS creates serious concerns that Harvard University has coordinated with the Chinese Communist Party and other foreign entities adverse to national security. And the evidence here is all, perfectly legal cultural and academic exchanges, the kinds of things universities do, or their donations from foreign nationals, which again, this is not a political campaign. That is perfectly legal. And even if it were not, it would not be the basis for withdrawal from SEVP. I've read those 19 subsections. And then it's covered over with a vague reference to Section 214.4, A2, subsection you wish you knew.
Right. One of the 19. I don't know which one.
Right. If the point here in manufacturing this document was to defeat a claim that this is an arbitrary and capricious agency action in violation of the Administrative Procedures Act, I think this hurts rather than helps.
Yeah, it's so clearly pretextual and so devoid of anything that the school could do to cure whatever defect there is being alleged, that I don't think it's going to help. But actually, I don't think that's the point, right? I think that the point is to kind of put something there that says, well, we're complying with the law when they're really not. Professor Leota Littman, who was on the show last month, she has an article in The Atlantic, which we'll link to in the show notes, where she talks about the administration's legalistic noncompliance, whereas they're spamming the docket with stuff that says, we're doing what we're supposed to be doing. We're completely complying with the court's order. And they're like 100% not. And I think that there's sort of two ways to look at this. Some of this is them saying, like, we actually did comply with discovery, or we actually complied with the court order. And some of it is what they did here, like back formulating a record that says, well, we may have jerked this benefit away from you illegally the first time, but we're now going to jerk it away from you legally. Like we saw this with the USAID cases where there was this DOJ went in and canceled all of the contracts. And the court said, no, that's an arbitrary and capricious cancellation of the contracts. And so, Marco Rubio went behind the curtain and came back 10 minutes later and was like, we've done an individualized, bespoke evaluation of each one of these contracts. And we've just canceled them all. So it wasn't arbitrary and capricious. It was, it was well thought through.
Yeah. And they claimed to review like 5,000 contracts in, a week and a half. It was obviously pretextual. And Professor Lippman's point that you were echoing here is the point is to just kind of wink at the courts and say, you've told us to do a thing. We're not doing that thing. And so you can either bless our invocation of this legal sounding language, or you can provoke a constitutional crisis. It's up to you. And that's how I see that. I think you're exactly right with the 214.4A2, right? Like it will not withstand the slightest bit of lawyer scrutiny. Like it took you and I about 5 minutes to go, that's not a thing. But the question is, are they going to get away with it?
Yeah. Okay, we're going to take a brief ad break unless you're a subscriber, in which case, not for you, baby. Not today, not ever. And we're back. Okay, staying in Boston. Let us now talk about one of the many immigration cases we're following, which is D.V.D. V.U.S. That's the one involving immigrants with final orders of removal who cannot be repatriated to their home countries for various reasons. The Trump administration is building what's effectively a global gulag so it can dump people into third country prisons, maybe indefinitely. That's the purpose of this SCOTUS in El Salvador. The government takes the position that it can do this more or less without any process. That is, it can shove human beings onto planes and drop them anywhere on Earth with no notice or ability to contest. The Convention Against Torture says otherwise, though, and so does Judge Brian Murphy, who ordered DHS to give prisoners reasonable notice and time to make the case that they should not be deported to that third country because of a credible fear of torture.
Yeah, and remember, the Supreme Court has already said in the Alien Enemies Act cases that notice of less than 24 hours before deportation in English, which virtually none of the deportees speak, with no mention of how those detainees can contest their removal, like that does not comply with due process.
Right. So there are a lot of moving parts in this case because the Department of Homeland Security just keeps breaking the law and sending the DOJ to retcon some kind of justification or excuse after the fact. So 3 things happened this week in the D.V.D. case. The first is that the government blamed Judge Murphy for starting not 1 but 2 civil wars in Africa.
You're not. I will say this for them, that those Trump lawyers do have huevos.
Yeah, that's one way of putting it. See, Judge Murphy stopped them from deporting people to Libya and South Sudan without process, which meant that people noticed that the government was going to deport people to Libya and South Sudan without process. And since no one wants to be a human rights pariah in service of imperialist America, that meant that the governments of Libya and South Sudan had to come out and deny that they were going to accept people who had been deported from the U.S. without process. And so don't you feel bad, Judge Murphy, for ruining American foreign policy?
What? I mean, don't you feel bad for insisting on due process and adherence to law and the Constitution, sitting federal court judge?
Yeah. So let me read you a little bit from this declaration submitted by Little Secretary of State Marco Rubio, because it's unbelievable. He says, in Libya, the court's orders have interfered with quiet diplomatic efforts and exacerbated internal political and security divisions in Libya. As factions opposed to Prime Minister Dbeibeh sought to capitalize on public reports of potential migration removals to Libya for political gain, Libya's Government of National Unity, GNU, publicly rejected the use of Libyan territory for accepting deportees. Rival authorities based in Benghazi also denied any agreement with the United States to accept deportees. In the context of this political unrest, GNU-aligned forces took action against the 2 largest armed groups in the Libyan capital on Monday, May 12th through 13th, sparking the most serious street fighting in Tripoli since 2022. As of May 21, the situation in Tripoli remains unsettled as GNU-aligned forces and their opponents seek to consolidate political and military support. On May 19th, a senior Libyan official informed the department that the unrest in Tripoli had forced a postponement in the announcement of a significant commercial deal to expand activities of a U.S. energy company in Libya. Yeah, the phrase "in the context of this political unrest" is doing some heavy lifting here. And Rubio had similar stuff to say about South Sudan and how the court's ruling ruined everything there.
They are literally making the, if you don't let us break the law, the terrorists win argument. But okay, so we talked last week about the flight that had left the United States with detainees of various Asian and Central American nationalities headed for South Sudan, a country we will remind you that the State Department says Americans should not travel to because of the high risk of crime, kidnapping, and armed conflict. And on the aforementioned May 19th, the government first told these deportees that they would be sent to South Africa, and then at 5:45 p.m. in the early evening, they said, whoops, we meant South Sudan. And then sometime around 9 a.m. on the 20th, that is the next day, about 15 hours later, the government loaded these people onto buses and shipped them to the airport. And the government's position is that that behavior complied with Judge Murphy's order because less than 16 hours after the close of business was enough time for these people to say that they had fear of being deported to an unstable country that didn't exist until 15 years ago and that the government didn't seem to know existed until 6 p.m. Unsurprisingly, Judge Murphy did not agree. He ordered the Trump administration not to relinquish custody of the detainees. They have since then been detained in Djibouti. After a long hearing that we listened to last week, the government agreed that it would give what are called credible fear hearings there in Djibouti. And the government promised that it would be under circumstances analogous to what they would have gotten here in the United States. And again, to emphasize, this was the government's proposed solution to Judge Murphy.
Yeah, and yet the government actually raced to the Supreme Court, skipping the First Circuit entirely to whine to the justices that Judge Murphy is, quote, usurping the executive's authority over immigration policy and disrupting sensitive diplomatic foreign policy and national security efforts by not letting them deport immigrants to war-torn hellholes without due process. So listen to how the Solicitor General, John Sauer, one of Trump's other lawyers, listen to how he characterized what went down here in his brief to the Supreme Court. He said, last week, the district court required the government to halt the ongoing third country removal of the aforementioned criminal aliens to South Sudan. The court did so by exploiting an open-ended term in its injunction, holding that the government did not give them a meaningful opportunity to raise a fear of torture in that country, notwithstanding that they were all notified that they were going to be removed there and that none expressed any fear at the time or even that day.
Yeah,
Doesn't that sound like they had a lot of time?
It does. I just have to break in and remind everyone that this is the case, D.V.D, where the government had to withdraw a sworn declaration claiming that a Guatemalan man who was kidnapped and raped in Mexico told a guard, that he had no credible fear of being deported back to Mexico. And the reason they had to withdraw that sworn declaration is because those events never happened. I mean, that they have just outright lied in this case, and they've been caught doing so.
Right. So continuing with Sauer, in the Supreme Court, he says, having slammed on the brakes while these aliens were literally mid-flight, thus forcing the government to detain them at a military base in Djibouti, not designed or equipped to hold such criminals, the court then retroactively clarified its injunction to impose an additional set of intrusive and onerous procedures on DHS. As a result, the United States has been put to the intolerable choice of holding these aliens for additional proceedings at a military facility on foreign soil, where each day of their continued confinement risks grave harm to American foreign policy, or bringing these convicted criminals back to America.
And now the foreshadowing pays off, right? Because, as we demonstrated at length, using their own words, it was the government's own suggestion that they, the Trump administration, hold those hearings in Djibouti. This was the court bending over backwards not to order Homeland Security to turn the flights around and return them to the United States. It was saying, can you give them due process outside of the United States? And the Trump administration argued in court, yes, sure. I really think this is not just garden variety bad faith arguing by John Sauer to the Supreme Court. I think this is sanctionably bad lying to the Supreme Court, right? It's just a complete, at minimum, lack of candor. Anyway, the Supreme Court does not seem in any hurry to respond. Justice Jackson, who sits over the First Circuit, gave the plaintiffs until June 4th to respond to the government's request for a stay.
Right. But meanwhile, The DOJ actually tried this same shit with Judge Murphy, which is, that is a choice.
It's one way of putting it.
Right. So the government filed a motion for reconsideration and stay with Judge Murphy that really kind of defies belief. They not only accused Judge Murphy of ruining America's foreign policy and forcing them to hold these guys in Djibouti, but they said this was all his fault because he didn't clarify what he meant by meaningful notice and opportunity to contest.
I am running out of ways to say mendacious, lying, shockingly disingenuous. Like, Liz, you and I listened to that hearing. Judge Murphy, again, did everything in his power to not micromanage the government. He asked them many, many times, just give me a workable rubric here. Tell me what to do. And not just at that hearing, by the way, like over the course of this entire case, it's just that the government flatly refused to do it.
Right. He said, you tell me what you intend to do to give these people meaningful process. And they said, we can't answer.
Yeah.
And he said, the Supreme Court said 24 hours wasn't enough, and they just turned around and did it in 16 and not in compliance.
Right.
So Judge Murphy denied that motion. Not a big surprise. And oh boy, was he mad. He said defendants have mischaracterized this court's order while at the same time manufacturing the very chaos they decry. So he quoted at length from the trial transcript to illustrate that the government is just lying. And he said something important, which is that due process isn't just for people we like. The Trump administration keeps attacking judges for like loving criminals or whatever nonsense, but like due process, criminal and civil procedure, that is what makes us American.
Here.
Or it used to anymore. He says, to be clear, the court recognizes that the class members at issue here have criminal histories, but that does not change due process. The history of American freedom is in no small measure the history of procedure.
Yeah, that is a cite to a 1945 Supreme Court opinion, Malinsky versus New York, that was one of the earliest cases to toss out a confession that was procured by coercion in the criminal context, right?
Right, because process matters.
Right. And Judge Murphy continues. He says, it is procedure that spells much of the difference between rule by law and rule by whim or caprice. Steadfast adherence to strict procedural safeguards is our main assurance that there will be equal justice under law. And that is a cite to another famous Supreme Court case. That is the Joint Anti-Fascist Refugee Committee versus McGrath. That involved the right not to be targeted by the government without due process. And look, this is why you and I use the phrase rule of law 20 times an episode, right? Like, he's right. This is a stirring and important part of our nation's history, and we're watching it disintegrate before our eyes.
Right. So Judge Murphy said, the court treats its obligation to these principles with the seriousness that anyone committed to the rule of law should understand. And that, I read that as him calling out lawyers who are participating in this and saying, you know better than to say that giving criminals due process is like favoring criminals. Process is what makes this system work.
Yeah, here. And I want to add what seems to be a positive development, right? Which is that the government submitted a declaration in which it said it is working to charter a flight to bring one of the plaintiffs back from Guatemala. That person goes by the pseudonym OCG. That is the gay man with an order withholding his removal to Guatemala, who was then sent to Mexico without opportunity to say he had already been victimized in Mexico. He fled Mexico to Guatemala and has been in hiding ever since. But like, importantly, in addition to the humanitarian, like, this is the government showing that they can get people back when they want to.
Yeah. Well, I read where J.D. Vance's campaign plane is being repurposed to fly deported migrants. It's like a charter plane now.
You're fucking kidding me.
I'm not. Yeah. Okay. So this show is already going to be like 10 hours long, but I do want to talk for a couple minutes about the government's conduct in the Kilmar Abrego Garcia case, because they really are running the same playbook in every court. Just delay, refuse to cooperate, and when they get caught, claim they just didn't understand the court order or they tried their best, the judge wasn't clear, whatever. So in the Abrego-Garcia case, Judge Exinas has twice in 3 days denied motions for extra time. The first was on a motion for a 30-day extension of time to file an answer to complaint because they, quote, expended significant resources coordinating across multiple agencies, reviewing and producing documents, preparing witnesses, and assessing complex privilege issues within the expedited time frame.
Yeah. Crimea River, Department of Justice.
Yeah, wait for it. So, okay, that motion asking for 30 days was filed on May 27th. Andrew, when do you think the answer to that complaint that they were asking for an extension, when do you think it was due?
Was it May 27th?
Ding, ding, ding. It was indeed. Is that normal practice to wait till the... No,
you know, I mean, it can be, but like, look, it takes you longer to file an opposed motion for extension of time than it does to file a complaint, right? Like, the only reason to do that is because you do not want to go on the record agreeing or even saying, like, you know, the defendant lacks a belief here, and so therefore, you know, on that basis denies the allegations in paragraph 12. That's what's bubbling beneath the surface here.
Yeah, actually, can you expand on that? I mean, I know we're already way long, but I do think that that's really an important thing. And we were going to talk about it maybe at the end of the segment, but I think it's important to talk about it now. The reason that they don't want to answer questions on the record is because they don't want to answer questions on the record. It's not like, oh, we've been, you know, researching so much and we've expended all that effort. When you have to answer in a complaint, the complaint says you did X, you did Y, you did Z, and you have to say, I did not, or I don't know, or I deny, I did not do these things. And the question here is going to be, you know, you sent this guy who had a non-removal order to El Salvador, and you did it anyway, right? And they don't want to answer that.
Yeah, and as I was alluding to, right, the standards for answering a complaint are very, very loose, right? Like you can admit, so like, you know, when paragraph 12 says the Department of Homeland Security is an executive branch agency, you admit that allegation, right? You can deny an allegation. You can say that's not true, or you can say we lack facts at this point in time, and on that basis, put the plaintiffs to their burden of proof of proving that allegation is true, right? So you don't have to take a lot of stances, but every time the government has said anything in any of these cases, they have immediately turned around and backtracked, right? Like Abrego-Garcia is the one famously where DOJ lawyer in court said, yes, that was a mistake, and then that turned out to be a mistake for his career. So, I mean, I just infer, you know, what you said, right? Which is they do not want to be pinned down in any way because everything is made up and back formulated, right? They want maximum flexibility to just take what the court says and then reinvent something after the fact.
Right. So Judge Exinas was apoplectic. Judge Paula Exinas, we've talked about her a bunch. She said defendants expended no effort in demonstrating good cause. They vaguely complained in 2 sentences to expending significant resources engaging expedited discovery, but these self-described burdens are of their own making. The court ordered expedited discovery because of defendants' refusal to follow the orders of this court as affirmed by the United States Court of Appeals for the Fourth Circuit and the United States Supreme Court. Further, as the docket plainly demonstrates, defendants are intimately familiar with the causes of action and the pending deadline. The court has conducted no fewer than 5 hearings in this case, and at no point had defendants even intimated they needed more time to answer or otherwise respond. Thus, to say now that additional time is needed to do that which the law requires rings hollow. Accordingly, the motion is denied. Womp womp.
I'm a little afraid to ask about the other motion.
Okay, so that one was filed on the 29th, and, you know, after they got yelled at for, like, just dashing off a couple paragraphs. In that one, the DOJ wanted a 2-week delay on responding to discovery requests, and because they just got yelled at for, like, dashing off a couple of stupid paragraphs, this time they spent a lot of time, like, listing all the very hard work they'd been putting into complying.
Just, as Judge Leon would say, please, that dog won't hunt. I mean, look, the DOJ is the biggest law firm in the world. Or, I mean, you know, used to be until Trump took over. The DOJ, even under Trump, can do doc review.
Yeah, well, in this one, the action was in the plaintiff's reply. TLDR, they say the government hasn't given them shit. Here's what they say they got from the DOJ, in addition to the facially defective privilege log. They say the first production comprised 58 documents 56 of which were copies of docket entries or discovery requests. The second production comprised 106 documents, 76 of which were publicly available docket filings, transcript materials related to Abrego Garcia's 2019 immigration proceedings, or plaintiff's discovery requests. The third production, made just last night, comprises just one document, Abrego Garcia's alien removal module file.
Yeah, so if I'm doing the math right, this is 32 or at most 33 documents that were not already in the public record.
And then there is a footnote. It's amazing. The government states that it attempted to contact plaintiffs to obtain their position on this motion, but were not able to obtain their position. In fact, while the parties conferred on discovery matters over email and phone over the course of the past week, including yesterday, the government did not raise its extension request until 11:35 p.m. last night, and then filed its motion an hour later without waiting for plaintiffs' response. Andrew, is that appropriate?
I should point out they misspelled obtain, but that's just me being petty. But no, I'm right. Like, look, everybody has the receipts, their email. They've got the little timestamp on it. I mean, I don't know what you're thinking. Like, you're going to look like an idiot in court when you do that.
Yeah. So, Judge Xenius was pissed.
Good.
And she said, no, you do not get delay. And furthermore, you have until next Friday. In fact, I think next Thursday to submit your privilege log, because I don't believe you. You've submitted such bullshit on your privilege log that you're going to have to submit all of the privilege documents to me. And I'll look at 5 of them in camera and I'll see if you're really allowed to make such privilege assertions.
I have to tell you, that is exceptionally unusual, right? Like, courts don't get involved in discovery disputes. And I have never in a case, even when the other side was acting in obvious bad faith, seen a court sua sponte say, of its own motion, I want to see your privilege log and I want to see all the documents you're withholding as privilege. I'm going to review a sample of them and then tell you on my own initiative if I think that withholding was correct or not. Like, I'm really glad, but I've never seen a court do that to a private party. To do that to the government is, it's just to your point that the government has lost all benefit of the presumption of regularity and is now, I think we could call, the presumption of irregularity, right? Like, there are courts where, it's just taken as a given. Oh, you're going to come in here and lie to me.
Yes, it is wild. Okay, we're going to take another brief ad break, let you spend a little quality time with our sponsors, and we will talk to you in a second.
And we're back. Okay, Liz, you and I have delved through some of the good and some of the bad, but I want to say there were a pair of very good decisions that came in Wednesday night and Thursday morning with respect to the Trump tariffs. I should say, because I think the news outlets have been very confusing about as of right now, those cases are administratively stayed pending appeal, but that really is just going to be a brief stay to permit the respective appellate courts to evaluate, right, to hold expedited hearings and not, radically change government policy before they get a chance to hear from the government. It's entirely appropriate. I don't read anything into that with respect to the merits. And I think we want to get into why these decisions are good, why we think they're going to be good in the long run, even though, it means there was Trump tariffs are gone, Trump tariffs are bad, right? Like, it kind of felt like the court running the same playbook that the administration did.
So the markets agreed with that assessment.
Right. Yeah, well, that's right. And we're trying to get to stability. So let's break it down. On Wednesday night, the U.S. Court of International Trade issued a permanent injunction blocking Trump's 2 major tariff orders and rescinding the changes made that increase the numbers in the U.S. Harmonized tariff schedule. The Court of International Trade is a full-fledged Article 3 court. It can issue injunctive relief. It can enforce its orders. It can hold litigants in contempt. It can do anything, a federal district court can. And then On Thursday afternoon, Judge Rudolph Contreras of the U.S. District Court for the District of Columbia issued a preliminary injunction in a parallel case in separate litigation in his courtroom, also blocking those same tariffs. And again, right, like that's just a normal federal district court.
Yeah, to be clear, the two decisions don't rescind all of Trump's tariffs, just the tariffs which were in response to so-called emergencies. Mm-hmm. So on February 1st, Trump announced tariffs on China, Mexico, and Canada, ostensibly to fight transnational drug cartels. Then on April 2nd, Trump held that ridiculous Rose Garden ceremony where he wandered around with like the poster board of reciprocal tariffs that he was announcing to combat trade deficits. That's the one that famously included economic powerhouses such as Vanuatu, Fiji, the Ivory Coast, and the Heard and McDonald Islands, the last two of which are inhabited only by penguins.
Make Antarctica great again.
Anyway, the point is that all of these very stupid tariffs were announced as part of the president's emergency powers under the International Emergency Economic Powers Act of 1977, known to its friends as IEEPA.
I love the way you said that. Okay, look, no president in history has ever tried to invoke IEEPA as a basis for raising tariffs. And as we told you at the time in episode 121, the law, IEEPA, does not give Trump the power to do what he claimed to do. And now two courts have held the same thing. No, it does not. And Liz, as you point out, it does leave other categories of very narrow tariffs intact, but like that's fine, right? Like those tariffs require public fact finding. It's why Trump didn't use them for the retaliatory tariffs, right? Like if his power is scaled back to just the authority he has under Section 301, like that's going to be much better.
Okay, so like we all know that the Constitution says that Congress has the power to lay taxes and levies being tariffs, right? That this power is a power that belongs to Congress. It can only sort of get to the president by delegations of power. The president doesn't have any inherent authority to levy tariffs.
Right. But what the Trump administration has argued is that when Congress passed IEEPA in 1977, it delegated that tariff authority to the president.
Right. It basically in its entirety. And like, no, that's not the law. IEEPA says that if the president declares a national emergency, Congress will give him certain limited powers to deal with any unusual and extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. One of those powers is to regulate importation or exportation in response to that emergency. Now, look, we know with a pretty high degree of confidence what Congress meant by those words because it's the kind of thing past presidents have done.
Yeah, right. This is things like freezing accounts of individual actors, right? Like, here's how a 2021 report from the Brennan Center for Justice put it. They said, let's say I'm a military general in a country and I'm responsible for a coup. The president can issue an executive order declaring a national emergency and invoke IEEPA. The Treasury Department would then sanction me, the military general, for those actions. So if I have bank accounts at a Chase branch, even outside the country, those accounts get frozen. And my Visa card doesn't work because Visa is an American company and it won't process my transactions. And even if I'm transferring money from Italy to India, if at any point that transaction goes through a bank in, say, New York, as do an awful lot of international transactions, the bank is going to freeze that transaction because I'm on the sanctions list. And, the Brennan Center, this is 2021, right, was arguing, hey, that seems like an awful lot of power to give to the president. Maybe we should cut it back some. But think about it, even as maximal as that sanctions power is, that's orders of magnitude less than the power to unilaterally raise tariffs on every country throughout the world, right? So that is like the background for the bad faith argument that says, well, IEEPA says you can regulate imports and tariffs are technically a kind of regulation. So, ipso fatso, that means Trump can do whatever he wants in perpetuity throughout the universe. And we're going to break down really the three reasons that these two courts have given why that dog won't hunt after our last ad break. And we're back. So, as I said before the break, I think there are really three kind of broad-based arguments here that arise out of these two court decisions. I think 2.5 of those are very conservative and have a really good chance at persuading, not just Roberts and Barrett, but, maybe even Kavanaugh or Gorsuch.
Yeah, well, I hope so, but who the hell knows? I mean, well, like we said in the post, those people have 401ks, they have retirement accounts, they have savings. They don't want to see them decimated in a trade war. So maybe.
Nice plug. Head on over to lawncastpod.com. You had a great post on that yesterday. But look, the three arguments are the non-delegation doctrine, the major questions doctrine, and what I'm kind of grouping together as various canons of statutory interpretation.
Okay. So under the non-delegation doctrine, right, we've said Congress has the power to levy tariffs. It can delegate some of its authority to the executive branch to carry out certain legislative priorities, but certain Article I powers are core and cannot be delegated. So even if the taxing power could be delegated, it must be limited. Congress can't just say, like, you get to do the budget, right? That's Congress's job, although I'm seeing how all these impoundment cases are going. We'll see. But the non-delegation doctrine comes from a 1928 Supreme Court case called J.W. Hampton versus the U.S., and that said that Congress must give an agency, quote, an intelligible principle on which to base its regulations. Congress can't just say, you do it. So the U.S. Court of International Trade, this 3-judge panel, said reading the words regulate importation in IEEPA as authorizing the president to impose whatever tariff rates he seems desirable would create an unconstitutional delegation of power. That is, Congress cannot give up that much taxing power to the president without more limits than there are in IEEPA.
Yeah. So you can see how this is a very conservative right-wing judicial doctrine, right? Okay, so that's non-delegation. Next up, second, is the major questions doctrine. So if non-delegation is conservative, the major questions doctrine is, to use the technical legal term, bullshit. So the major questions doctrine was invented by the Roberts Court all the way back in 2022 in a case called West Virginia versus Environmental Protection Agency, where the Roberts Court said that, if Congress had intended to give the EPA the power to regulate coal plants, they would have explicitly said, you have the power to regulate coal plants. And since they didn't say those words in that order, that meant the EPA didn't have that authority. And the argument is that Congress, here I'll quote from the decision, rarely provides an extraordinary grant of regulatory authority through language that is modest, vague, subtle, or ambiguous. So the idea is that if an executive branch agency claims the power to resolve an issue of vast economic and political significance, right, that is a major question, then courts should expect Congress to have clearly delegated that authority to the agency.
Yeah, just to be clear, the way that shakes out, the way that the rubber hits the road with the Supreme Court is that the Supreme Court can see the executive branch do something, a Democratic president do something, and say, no, you can't do that because it's too much of a major question. What's a major question? Well, it's whatever 6 justices on the Supreme Court, or 5 actually, deemed to be a major question. And they say, no, the executive branch, even if there's a law, it's too big for Congress to give to the executive branch to decide. I mean, that's why it's bullshit, because it's this basically, it's vibes. It's just like all vibes.
Yeah, Democratic presidents have to run back to Congress, that's been broken for more than 2 decades. Republican presidents can, of course, impound funds at will and, fire agency heads that are protected by law and everything. Okay, so those are the 2 doctrines that these courts seized upon that said, hey, you guys like these very conservative legal principles, and what Trump is doing clearly violates these doctrines, right? Like, it obviously violates the major questions doctrine. Like, being able to unilaterally change tax policy throughout the world based on your reading of the word regulate is, I cannot think of trying to cram more power into a more vague delegation than that. So I mean, that's the thing that I expect the Roberts Court really to bite on when they evaluate this case. I also think there are sound legal reasons for this, right? Like one of those sound legal reasons are the applications of the canons of statutory construction, right? And so what you do is you use the ordinary tools to try and figure out what Congress intended when it said regulate imports and exports. And here, Judge Contreras raised an issue that I hadn't thought of. And it is based upon a long-standing principle that says you don't interpret a law in such a way as to render that law unconstitutional. And so let me try and play this one out. IEPA says that the president has the power to regulate imports or exports. And so if Trump is right that regulate means impose a tariff, that would imply that he can impose import tariffs and export tariffs. And the problem is export tariffs are explicitly prohibited by the Constitution. And the reason why export tariffs are unconstitutional is because, right, the tariffs that, we've talked about a lot are import tariffs. Those are the ones that are permitted. That is goods coming into the country. Taxes on goods going out of the country, those goods come out of a particular state. And so if Congress had that power, they could say, oh, we're going to tax exports from Maryland, but not exports from Pennsylvania, right? They would let them discriminate among the states, punish states that were in favor or out of, right, or out of. And so at the time of the founding of the Constitution, the framers were like, we want to make it totally clear that Congress definitely doesn't have the power to impose export tariffs. And so if Congress doesn't have the power to impose export tariffs, then they can't delegate it to the president, right? That would make it unconstitutional. And that means when they said regulate import or exports, they were not thinking of tariffs. They were thinking of freezing assets in the way that you described, Liz.
Yeah, I don't love this argument. I've got to say, right, that I think that Trump administration's response is going to be, well, then just cross out export, right? Like there's a canon of statutory construction that like if one piece of a law doesn't work, then you just like X that part out so that the law holds. I mean, I think that the way that this is going to shake out is that the D.C. Circuit or the Supreme Court is going to say, no, Judge Contreras, you don't have jurisdiction. This belonged in the U.S. Court of International Trade, where the other case was, and then they can just deal with whatever, then they only have to come up with one bullshit justification or something. Right? I don't see this one surviving. I just think it's a little too clever.
Yeah, you might be right. The way in which Judge Contreras squared that circle was to say, look, if the power to levy tariffs is not within IEPA, then by definition, I have jurisdiction, right? Like the only way that the Court of International Trade has jurisdiction is if it does contain tariff policy. So, that I think there are going to be a lot of interesting procedural questions, but like at the end of the day, like I think there's sufficient meat on the bones here. Like, look, we may get a decision that expands the major questions doctrine in ways that we find terrible, right? As, proponents of having the government do things. But I think if it is used to restrain the Trump administration, like, I'll take that now and figure out how to fix the Supreme Court later.
Yeah, look, let me just say, we've seen the Supreme Court in all of those impoundment cases try and send all of these impoundment cases to the U.S. Court of Claims, right? Which is some, bullshit side door court. No offense to the U.S. Court of Federal Claims. I do not for one second believe that they're going to let Judge Contreras' opinion hold. But okay, let's talk for a minute about what's going to happen here going forward, which is, as you said, the Federal Circuit, which is the appeals court for the U.S. Court of International Trade, the CIT. They have administratively stayed the trial court's order. That is not a decision on the merits. That's not saying, we believe that you are more likely or not to succeed based on the, injunctive relief factors. That means that they're going to brief it, and it's a very fast briefing schedule. I believe that the whole thing has to be briefed, both sides, by June 9th.
Yeah, and they could expedite it, right? Like that administrative stay just said pending further order of this court. So yeah, it's going to be fast tracked. Judge Contreras on his own stayed his order 14 days to permit an appeal to the DC Circuit. As of this record, I don't know if the government had filed that appeal. I don't think they had, but they will within the 2 weeks. And then, there will be emergency motions to stay at those appellate courts. And then whatever happens, it will go up to the Supreme Court. And in my view, I'm curious your thoughts on this, Liz. Like, I think the Supreme Court's going to tip its hand, right? Like, and effectively, what the Supreme Court rules is going to decide whether Trump has those IEPA powers, right? Like, if they stay the CIT opinion and or the district court opinion pending a disposition on the merits, which is going to take a year and a half, right, to brief and for the Supreme Court to decide. Well, I mean, that is functionally a determination that yes, Trump can impose tariffs by fiat. And if they don't stay it, right, if they block those orders, then that's functionally a decision that no, you can't do it by fiat. So I think we're going to know in a couple of weeks if Trump can screw around with the economy on a massive level or not.
Yeah, I actually think this is going to be worse than what you have said.
Oh, good.
Unbelievably. No, I think that the Supreme Court will, in fact, stay the lower court's orders, right? And pending a determination on the merits. So that is that they will let these tariffs go into effect. They will let Trump screw around with the economy for a year and a half while this thing gets briefed. And then they'll say, oh, actually, we decided you didn't have the right to screw around with the economy, because they'll get sick of having their stock accounts get all decimated by this dumbass trade war. I really do think that that's what they're going to do. Like, the most stupid and destructive thing is probably what's gonna
always bet
I know
on
you're
bread.
like, wow, I didn't see that one coming. Way to bring it down. All right, look, you guys, that's not what's going to happen. It's going to all be fine. The Supreme Court is going to say that the president does not get to steal Congress's tariff power. That's how it's going to shake out. Do not worry. You heard it here first.
Hear, hear.
All right. Have a lovely weekend. Thank you guys for sticking with us. And we will see you on Monday with written content and on Tuesday with another podcast. See you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.